Morning, Miss Esther.
Good morning. May it please the Court, I appear with Mr. Birdling for Dana Astra, Sir James Eady, Jason Pobjoy and Rayan Fakuri here for the Foreign, Commonwealth and Development Office. As you know, this is an appeal against the order of Mr. Justice Saini dismissing Dana Astra's challenge to its designation under Section 38 of the Sanctions and Anti-Money Laundering Act. I will address where we suggest that the judge's approach with respect was wrong in relation to both rationality and proportionality. That's grounds 2 and 3. Mr. Birdling will then address you on two legal points relevant to proportionality. First, and briefly, the approach that we would suggest it's appropriate for this court to take to proportionality post-Spidler in the Supreme Court. And secondly, why we say the judge was incorrect on jurisdiction for the purposes of the ECHR. That's ground 1. As you know, Dana Astra is designated pursuant to the Republic of Belarus Sanctions EU Exit Regulations 2019. That's the UK's Belarus sanctions regulations that were made under the Sanctions and Anti-Money Laundering Act. And could I ask you please to look at the regulations which are in the authorities bundle at tab 27. They start at page 1722. If I could ask you first please to look at page 1726, where you should find regulation 4, the purposes of the regulations. The purpose of the regulations contained in this instrument, says regulation 4, that are made under section 1 of the Act, that's the power to make regulations for various purposes, are to encourage the Government of Belarus, and relevantly for this case, in B, to refrain from actions, policies or activities which repress civil society in Belarus. I don't know if you all have the right, you with me, tab 27, yes. So yep. Policy to refrain from, to encourage the Government of Belarus to refrain from actions, policies or activities which repress civil society in Belarus. And if you carry on to part 2 over the page 1727, you will find part 2, designation of persons, and the power in regulation 5 to designate persons. The Secretary of State may, so that's the relevant discretion, designate persons by name for the purposes of any of the following, and in little a you have the financial sanctions restrictions that we're concerned with here. So that's the discretion, power to designate, and then if you look on to 5A, the conditions for the designation of purposes by name, 5A2, paragraph 3, which we're coming to, applies where the Secretary of State chooses to designate a person mentioned in 5.1 under the standard procedure, and we are dealing with the standard rather than the urgent procedure in this case. So paragraph 3 applies. Paragraph 3 says, the Secretary of State may not provide that a person is a designated person under regulation 5.1, that's the discretion we saw, except where condition A is met. And condition A, if you read on to subsection 4, is that the Secretary of State has reasonable grounds to suspect that that person is an involved person. And if you look then to regulation 6 on page 1731, you will see meaning, designation criteria, meaning of involved person. And under subsection 2, for the purposes of 5A4, that's what we've just seen, that was condition A, the condition relating to the designation of persons by name. And we're dealing here with by name, not by description. An involved person, that was in condition A, means a person who, A, is or has been involved in, and then relevantly for this case, you see little 3 and little 4, the repression of civil society or democratic opposition in Belarus, and under little 4, other actions, policies or activities which undermine democracy or the rule of law in Belarus. And then you'll see 7, obtaining a benefit from or supporting the government of Belarus through carrying on a relevant business activity. And if you then go down to the bottom of the page to 3 big A, for the purpose of this regulation, being involved in obtaining a benefit from or supporting the government of Belarus through carrying on a relevant business activity, so that's the little 7 that we were just on, means carrying on business in a sector of strategic significance to the government of Belarus. And if you then scroll down to 4 definitions in this regulation, you will see that one of the defined phrases is sector of strategic significance to the government of Belarus, and that includes the Belarusian construction sector. Now I'm going to come back to that in a moment, but just so you see it, Dana Astra is designated for 2 reasons under those criteria. And you can see the reasons in a number of places, but one is the sanctions designation form, which is the statement of reasons from the government, and you'll find that at tab 3, page 48 of the supplemental bundle. And if you look at the UK statement of reasons on page 48, you will see the 2 reasons. So UK statement of reasons, Dana Astra is an involved person under the regulations we've just looked at because, and you'll see a 1 and a 2. So 1, Dana Astra has been, so that's past, involved in the repression of civil society or democratic opposition in Belarus, or other actions, policies or activities which undermine democracy or the rule of law in Belarus, namely as a sponsor of the Belarusian National Olympic Committee. Now, for your note, the listing criteria that we just saw in the regulations that contain those criteria were regulations 6.2a, little 3 and little 4 that we looked at just now. So the criteria that the government rely on are has been involved in the repression of civil society, just to put it shortly, or other activities which undermine democracy or the rule of law. And then the second reason is that Dana Astra is, that's present tense, involved in obtaining a benefit from or supporting the government of Belarus through carrying on business in a sector of strategic significance to the government of Belarus, namely the Belarusian construction sector. Now, I will make submissions briefly on the judge's errors in his approach in relation to both reasons, in relation to rationality and proportionality. So first, I'll start with carrying on business in the construction sector, and then I will look at the repression of democratic opposition in Belarus as the 2 reasons. So first, the Secretary of State's case is that it has reasonable grounds to suspect that Dana Astra is obtaining a benefit from or supporting the government through carrying on business in the construction sector. Now, we don't challenge the threshold question here. In other words, that the Secretary of State has reasonable grounds to suspect that Dana Astra is an involved person. But that is only the first question under the regulations. There are 2 separate questions. First, does the Secretary of State have reasonable grounds to suspect that someone is an involved person? And if so, as you've seen from the regulations, that gives the Secretary of State a discretion, power to designate, which has to be exercised reasonably, proportionately, subject to the jurisdiction point. As Mr. Justice Jay put it in the Synesis case, which I don't ask you to look at now, but it's Authorities tab 22, paragraph 23, the defendant, that's the government, clearly has a discretion to designate, and the inquiry does not notionally cease as soon as he has reasonable grounds to suspect that the entity at issue is an involved person. So we say it's very important that there are 2 separate questions, and both are necessary. Question 1, what we have called in our skeleton argument, the threshold criterion, do you get through the gateway? Are you an involved person? And you saw that there is a condition attached to that. We'll come back to that in a moment. Are you an involved person? Now, vast numbers of people are involved persons for the purposes of the Belarus and indeed the Russia regulations, which for these purposes are pretty similar. A number of people in this room get through the gateway of being an involved person. Now, that is necessarily so, and I'll explain that in a second. It necessarily so because I'm sure the government's case that it is very important that there are lots of people in the potential net of people who could be designated by the government because of the very important purposes that the Belarus and indeed Russia regulations serve. But it's enough to be an involved person for Belarus and Russia sanctions purposes to be, for example, associated with anyone who has ever done business in Russia in most sectors of the economy. So anyone here who's been paid to act for a Russian client who used to be in business in Russia, or who have been paid to sit as an arbitrator, all will be involved people for the purposes of the regulations. And as I said, intentionally broad and relatively easy to get through that gateway because the standard is reasonable grounds to suspect. But that is just the starting point. Then there is the discretion in Regulation 5. And what is stopping a number of people in this room, one hopes, from being sanctioned on the basis of a mere suspicion is the reasonable exercise of that discretion on public law principles and this court's review. So in this case, on question 1, we have to accept that Dana Astra is in some sense carrying on business in the construction sector. And that is because, as you've seen, it is not allowed to do otherwise. As the judge correctly found in his factual findings at paragraph 21 of his judgment, and you don't have to look at that paragraph for now because I'm going to summarise it, because of the attitude of the Belarus government, by means of a series of decrees and letters, there are very severe restrictions imposed on Dana Astra, as a result of which, and again the judge correctly found this, Dana Astra is not allowed to divest itself from the project it is engaged in, the Minsk World Project. It has been threatened with and subjected to expropriation, effectively, and this is my phrase and not the judge's, a corporate raid. As the judge did put it, Dana Astra faces real challenges, even operating effectively in Belarus at all. Now, you may have seen that the Deputy General Manager of Dana Astra, Mr. Mulic, put in evidence to the court showing that the judge's factual findings are very well justified. And just a few references here. His first statement, paragraph 18, says this: if Dana Astra fails to fulfill its obligations in relation to Minsk World and ceases its operations, the entire Minsk World project would be automatically seized by the government of Belarus without compensation and without assuming any of Dana Astra's debt. So pausing there, obviously a huge windfall for the government of Belarus were that to happen. In his second statement at paragraph 8d, you have figures showing that it is on the verge of insolvency. And in his first statement at paragraph 32, it is being subjected to effectively a corporate raid by the government. Numerous contractors have withdrawn from the project. And in his first and second statements, you'll see evidence of its workers being harassed and intimidated by the state, the project derailed by constant, unjustified and onerous inspections, leading to administrative fines for delay in completing the project. So because Dana Astra is carrying on business in the sector, albeit with a gun to its head, the regulations say that for condition 5A purposes, that in itself means that the box is ticked of benefiting from the government. The box is ticked for Dana Astra being an involved person because the regulations say, as you will recall, that for the purposes of that condition, 5A, supporting the government and benefiting from the government means carrying on business in the construction sector. But, and this is a crucial point, That just gives a discretion as to whether to designate. Whether to exercise the power under Regulation 5. It simply puts Dana Astra in that vast net of people who could be designated. And our challenge is to question 2, the exercise of that discretion on these facts. We say there is simply no rational basis for the Secretary of State exercising a discretion to sanction Dana Astra for benefiting from or supporting the government of Belarus on the facts. This is in effect a deeming provision, the part of the regulations which say that you benefit from the government if you are carrying on business, that is Regulation 6.3a, we say simply does not apply to that second question, the exercise of the discretion or the proportionality stage. And I think it is useful just to look back at the regulations once more time just to see why that is so. So the discretion, and they are at tab 27 of the authorities bundle if you don't still have them open. Just as a matter of construction of these regulations, the discretion to designate, the power to designate persons is in Regulation 5. Condition A must be satisfied in order to exercise that discretion. That's 5A.
So which page are you on?
Page 1727 is the power to designate. So may designate persons by name is a discretion. The conditions for the exercise of that discretion are at page 1729. That's 5A. And that says that the Secretary of State may not provide that someone is designated, except where condition A is met. So the condition for the exercise of the discretion is that condition A is met. Subsection 4, and sorry to repeat this, but it is important. Condition A is that the Secretary of State has reasonable grounds to suspect that someone is an involved person. And the definition of involved person is at page 1731, section 6. And it's within that definition of involved person that you get what we might call a deeming provision. That if the Secretary of State says this is an involved person, because they have been involved in obtaining a benefit from or supporting the government of Belarus, in other words, that little Roman numeral 7, then you have to look at 3A at the bottom of page 1732, and that says, for the purposes of this regulation, being involved in obtaining a benefit from or supporting the government of Belarus, in other words, that little 7 listing criterion, means carrying on business of a sector of strategic significance. So for the purpose of question 1, the threshold gateway question, you have to accept that you are obtaining a benefit from the government or supporting the government if you are in any sense carrying on business in the construction sector. That means you're an involved person. But all that does, that provision, is gives the power for the Secretary of State to designate. In other words, gives a discretion. And our submission is, and I'll come on to the judgment in a minute, that when you come to the exercise of that discretion, when the government does in section 5, the government can and must look at all relevant factors in the exercise of its discretion. It must exclude irrelevant factors, as always. It must consider relevant factors. It must make proper inquiry. And the court, importantly, must itself look at all the facts as it ordinarily would when it comes to consider proportionality. Now, these, we say, are key safeguards that both the Secretary of State must exercise its discretion in accordance with public law principles, and that the court must perform its important role in relation to proportionality, subject to Mr. Birdling's jurisdiction point, because sanctions powers are severe, and otherwise, if the government's case is correct and if the judge's judgment is not overturned, sanctioning individuals will be a simple tick-box exercise on the basis of mere suspicion that you are an involved person in one of these enormously wide categories, and that's it. But aren't
you eliding to principles? I mean, it's all very well to say, of course, the government has to exercise the discretion under the regulation, as you say, the word is may, and it has to exercise its discretion on public law principles. That's clear, and you challenge whether it did. The second question is whether Article 1, A1P1 is engaged. Only if it's engaged do we get to the Schvidler proportionality exercise.
Exactly right.
And so you can't elide them and say discretion and proportionality.
You're quite right.
Yeah.
I was sloppy with my language. You're quite right, and that's why I said subject to the jurisdiction point.
I think it's really important
Yeah.
to deal with the grounds of appeal separately, according to whether we're dealing with a public law challenge to the exercise of the discretion, or whether we're dealing with A1P1 and then Bank-Mellat tests and so on.
I entirely agree and apologise. So I am dealing with errors in relation to rationality by the judge and the factual basis for proportionality. And then Mr. Birdling will deal with whether we are in A1P1 jurisdictional
Let's
territory.
keep proportionality separate from rationality.
Well, the reason that may be more complicated because of the way the judge approached this, but I'll show you that in a moment, if I may. Because that elision is one of the errors that we identify in the judgment. But let me show you. So I've just made the submission that these are key safeguards, that there is this discretion and so on. And that is partly because, as we've identified in our skeleton argument, there has been a watering down over the years of the safeguards in relation to sanctions regulations. So the requirement that designations be appropriate has been removed. The requirement that designations are regularly reviewed has been removed. And the right to damages in most instances has been removed. So this, we say, is extremely important. Now, in this case, our submission is that with respect, the judge was in clear error in his approach to rationality, because his view, which I will show you now, is that if you tick the involved person box for question 1, because you are carrying on business in a sector, then that deeming provision, as I've called it, regulation 63A, which deems you to be supporting the government for question 1 for that gateway, you recall it says means, supporting the government or benefiting from the government means carrying on business for that purpose. His view is that if you tick that box, that involved person box, then that effectively determines your discretion for the purpose of question 2, the discretion, and without wishing to elide the 2 issues, and for the proportionality analysis. He says effectively, and I'll show you the place now, that you cannot look at the facts at all because of that deeming provision. And we see that in paragraph 80 and 81 of the judgment. If I could ask you to turn up the judgment, please. It's at tab 3 of the 4 bundle, starting on page 77. So there are 2 paragraphs where he does this because there are 2 reasons. Paragraph 80, which is on page 100, and paragraph 81 on page 101. I argued, as you see at paragraph 80, that Dana has not benefited from or supported the government of Belarus. I reject that submission. Dana has not challenged the Secretary of State's determination that it is an involved person by virtue of having obtained a benefit from or supported the government of Belarus through carrying on business in a sector of strategic significance to the government of Belarus. It is not open to Dana in those circumstances to challenge the Secretary of State's rational connection analysis, pausing there, that was proportionality.
But that's proportionality test 3.
Correct.
That is not anything to do with rationality challenge.
I agree with your lordship entirely, but the judge didn't see it that way, and I will show you where it is. He deals with our rationality challenge to the exercise of discretion in the same place that he deals with the rational connection point. And one can see maybe why he did that, because you could say the factual basis for our submission was the same.
Okay.
So it's not open to Dana to challenge Secretary of State's rational connection analysis on the basis that it has not in fact obtained such a benefit. And then paragraph 81, I argued it cannot be assumed from our client's sponsorship of BNOC, and I'll come on to that it has enabled or facilitated the repression of civil society in Belarus. I have found Dana was rationally found by the Secretary of State to be an involved person, so that's that gateway. On this additional basis, i.e. the Olympic sponsorship as well as carrying on business, it is not open to Dana to challenge the Secretary of State's proportionality analysis on the contrary factual basis. And we submit that this is incorrect as a matter of construction of the regulations, and I have already shown you why, and as a matter of principle. And just to test this for a moment.
I don't understand why you say that. This is, the question here is the rational connection question in Bank Mellat 3, right?
Yes.
And the rational connection question is on the assumption that you have become an involved person. You are an involved person. And the rational connection is between the interference with the Article A1P1, it's all about human rights in A1P1, and the measure that is being taken, namely the introduction of sanctions. There has to be some rational connection between that measure and the interference, to justify the interference, right?
Right.
It's not about the facts. It's about the situation that he has. The regulation says you can do it if you pass this threshold, and then you have to show. It's best to bring up Bank Mellat. It's in the judgment, I think. What's the words of Bank Mellat? It's
the four-stage test.
And where is it in the judgment?
Where is it?
He's set them out in the judgment. It's very well known by everyone except me, but I just like to get the words exactly right. Yes. It's early on in the judgment, I think.
I think it's set out in the skeletons.
Oh.
77 of Mellat.
100 of the judgment.
Sorry, it's Bank Mellat 2, isn't it? Whether the measure is rationally connected to the objective.
Yes.
Paragraph 77 of Mr. Justice Saini's judgment.
Yeah, that's what I'm looking at now. So, four broad matters arise from decision whether the objective of the measure is sufficiently important to justify the limitation of the protected right. Right? So the objective of the measure is to bring about change in Belarus, and the question is whether it's sufficiently important to justify the A1P1 interference, and whether the measure, that is the measure that is taken, the sanction, is rationally connected with the objective of the measure, in other words, to achieve change in Belarus. So how does the interference with Dana's rights and its connection to the achieving of change in Belarus engage the facts of the involvement of Dana? It's simply a question of, yes, of course it's rationally connected to sanction people and interfere with their A1P1 rights, because that is likely to change things in Belarus. And Dana is a very big company and it's doing a very big project. And if you mess up their ability to trade, you may do what the government thinks will be achieved. So it's simply a rational connection. It's not a factual issue. It's not the fact that Dana has got a very bad situation in Belarus, and I know you've got a vast amount of evidence about how terrible things are there and how the government there is doing bad things to Dana, but that's not really the question. The question is the rational connection question, and you have to keep clearly in mind whether the measure, and the measure is the imposition of sanctions on Dana, is rationally connected to the objective, that is the change of the situation in other words, to improve the situation, human rights situation, whatever, in Belarus. Now, I just don't understand the argument that he got that wrong. He said that's not the question.
May I try again?
Yeah, try again.
Okay, first of all, and I haven't shown you this, but Mr. Justice Saini dealt with, remember I said there are two questions on the rationality. There's, are there reasonable grounds to suspect that you're an involved person? Question one. Then there's question two, the rationality of the exercise of the discretion. Under question two, we say, of course, the facts are in play, because we say it is simply irrational.
Of course they are, but he's not dealing with question two, rationality.
If your lordship looks at paragraphs 72, 82 and 95,
okay, well, let's
and that is dotting around. Can I make the submission?
Well, let's look at 72, what did you say, 72, 82 and 95?
Yes. So in these paragraphs, having recognised in principle at paragraph 29, I appreciate you're trying to read, but having recognised in principle that there are two separate questions, there is the involved person gateway, and then there is rationality. He then, in those paragraphs 72 and 82, we suggest, look simply at, are you an involved person? And if so, is it proportionate to designate you? He skips over the question of, is the key question, is this a reasonable exercise of discretion to take this person from that enormous net and sanction them, which is a key question on the facts. The reason he ignores that question is because, as you'll see from paragraph 95, he dealt with our arguments on rationality and discretion in the same passages as he dealt with rational connection. So he says, under rationality, he says this ground is parasitic on the arguments made in relation to rational connection aspect of the proportionality analysis and is without merit a fortiori given the lower standards of review. An irrational decision is a decision which is not logically explained by reasons. Rational reasons were given for the designation. It's hard to see how a decision the court has found to be proportionate could be irrational under conventional law principles. So with respect to the judge, nowhere in this judgment does he consider our central argument, which is that on conventional public law principles, it was an irrational exercise of discretion to take this company that came through the initial very wide net. Yes, it's an involved person, because so is everyone who's carried on business in Belarus. But he has not considered the factual question of, is this a rational exercise of discretion?
Well, he says, I mean...
He says it's all the same arguments, so I'll deal with it in that section, which is dealing with proportionality.
I'm not suggesting whether you're right or wrong, Mr. Lester, but I want to try and keep it on a logical track. That there is an entirely separate question as to whether the discretion, the exercise of the may power, having gone through the gateway and found you're an involved person, which you don't challenge, there is a separate question as to whether the exercise of that discretion can be challenged on public law principles of rationality. And he deals with that in paragraph 95. Right? That's where he deals with it. There is an entirely separate question which requires you to prove Article 1, jurisdiction, to get through A1P1, to engage A1P1, and then to say that under Bank-Mellat Test 2, there is no rational connection between the measure and the objective. And those two questions he deals with separately. Good or ill, you may say he's wrong and it should have dealt with them differently, but he deals with the Bank-Mellat 2 question very clearly at the paragraphs we looked at a moment ago under the heading of proportionality, which is taken by public lawyers to mean the exercise we're talking about under justifying an infringement of the convention. And it starts at paragraph 68. It's all about the Bank-Mellat tests, with which many of us are super familiar, even if we can't recite them. And he comes to Bank-Mellat Test 2 at 80 and 81, and he says at 80, he says, I'm talking about rational connection analysis, and then 81, he talks about proportionality analysis, and 82, he says we're talking here again about well, no, he then talks about the proportionality analysis. But he's not talking about rationality. Maybe he has taken into account some of the things that he said here later. But you have to attack on rationality, paragraph 95.
Indeed. My submission, which I'm not making obviously very clearly, is that the error he has made permeates his discussion of rationality and proportionality, and we are in entire agreement about the proportionality test and the fact that it comes down to exactly the factors set out in Bank-Mellat. But in both cases, in relation to whether the discretion was reasonably exercised and the proportionality analysis, which again we agree entirely is subject to jurisdiction, in both of those cases, the error that he made with respect was to say that we cannot make any factual argument because we've accepted, or he has found, that the involved person box was ticked. That's all. That's my whole submission.
So can I just maybe see whether I've understood what your argument is, and I might have got it wrong. As I understand it, what you're suggesting is that the actual factual position, perhaps as asserted by the appellant, is relevant to rationality and proportionality. Because your argument is, yes, we're through the gateway, but it's still open to us to challenge the assumptions that are made by the regulations.
That's exactly right. And the reason why that is exactly right, if I may say so, is that the regulations make clear, and I've taken you to them twice because it seems to me they make entirely clear that the only purpose of that deeming provision, which says you are automatically deemed to be supporting the Government of Belarus, even if you're not in actuality, and even if it's in touch, that only goes to that gateway question.
So your point is, look, the Government of Belarus is being horrible to us, and the idea, okay, yes, we're through the gateway, the legislative assumptions apply, but it's not rational to exercise the discretion against us because actually, in fact, we're having an awful time.
Exactly, and I'm going to come on to that. But just in relation to one point, my lady, where you say it's the facts as alleged by the appellant, in relation to this ground, it's the facts as found by the judge.
Right.
And that's why I showed you and pointed to paragraph 21 of the judgment. It is the judge's factual findings that Dana Astra is not allowed to exit the market, not allowed to divest itself.
Yes, sorry, that's a helpful qualification.
That it's subject to very severe restrictions, that it's being threatened with expropriation, and faces real challenges operating at all. So that is exactly right. And can I just...
Before you do go on, can I just try and explain what I was trying to put to you? I completely understand my lady's point. And indeed, it seems to me, at first sight, that it could be argued that the facts come back in at the exercise of the discretion stage. In that, you could say this is an irrational decision because on the facts, although on the wording of the statute the gateway is passed, there is no rationality in imposing sanctions on this person because X, Y, and Z on the facts. I understand you could say that. But if you're challenging the judge's decision, you have at least to address paragraph 95 where he addresses what he understood your argument to be. And he said that the rationality, I mean, you're right to say that he does describe it as parasitic, so he does connect the two. I entirely accept that too. But he says you can't challenge it on rationality grounds because an irrational decision is a decision which is not reasoned, and this is a rational reasons have been given.
I agree entirely, and I'm coming on to why it is an irrational decision, despite what the judge says. Absolutely, that is a separate error. The only point I have been making and labouring is that he is effectively putting a fetter on looking at the facts.
But the point that I'm balking at is that he doesn't say in terms, I'm not, apart from the word parasitic, he doesn't say, I'm not looking at the facts in considering rationality. What he says is, I'm not looking at the facts in considering Bank Mellat too. And
that may be a fair construction. Our reading of this judgment is that he's doing it in relation to both.
Well, because of the word parasitic.
Because of the word parasitic and because of the structure of the judgment, the whole of the analysis of rationality is under the same heading as rational connection.
And it's paragraph 29 of the judgment. I mean, do you rely on that as suggesting that perhaps the judge misunderstood what your argument was?
Well, I am a little mystified, my lady, because in paragraph 29, it looks as if the judge clearly recognises the point I made. So if you look at the middle of 29, he says he hadn't realised until the oral hearing that we were in fact saying, for the purposes of the other reason, which I haven't yet come on to.
Which sentence you
Sorry. If you look at the sentence starting, it is hard to read this in the middle of paragraph 29 on page 87. He is referring there to our pleading. So our pleading said the Secretary of State couldn't, on the basis of the material before him at the time of the review, rationally have concluded that the matters which led the Secretary of State concluding that the claimant fell within the definition of involved person disclosed sufficient grounds to justify maintaining his designation. So he takes our pleading. He says it's hard to read this as anything other than a complaint about the exercise of the discretion to maintain the designation of a person who it is accepted as an involved person. Now that sentence makes it look as if he is recognising, and we, with respect, agree that there are two questions which need separate analysis. There's the do you get through the tick box involved person, and then is there a separate exercise of the discretion? But the reason I then refer your lordships and ladyship to paragraph 72 and 82 is that when it comes to his analysis, he only looks at involved person and then proportionality, and indeed so does the government. And
but it's potentially, that sentence is potentially ambiguous because it might be read as suggesting that what the judge thought you were complaining about was, oh, the mere fact that we're involved persons means that the discretion has been exercised against us. Whereas as I understand the point you're now making, that wasn't your argument. Your argument was a slightly different argument, which was there's a distinction between falling into the net and then sufficient reasons to pluck you out of the net, and you say, well, you know, we're having a rotten time, so the discretion shouldn't have been exercised against us. I mean, I'm slightly oversimplifying.
But if you then look at 72 on page 99, he says that the starting point for any proportionality assessment must be that Dana falls within the class of persons in respect of the Parliament's lawfully determined that there is or may be a legitimate public interest in their designation. Now, that is the net, the gateway.
Yeah.
Although that is not the end of the inquiry where human rights considerations are engaged. Now, that suggests to me, and the same as at 82, that he is only looking at the gateway involved person question and then at proportionality. And he is not looking at the all-important question of, is this a rational exercise of that Regulation 5 discretion at all? He is simply skipping over that question.
Well, he's not skipping over it because this is in a section marked proportionality. I mean, you may have a very good, I don't know whether it's in your grounds of appeal, we'll have to look. You may have a very good case for saying he never considered whether the discretion was properly exercised on public law grounds, except to say that they gave reasons. And
Right.
and you may have a very good case for saying when he refers back by using the word parasitic, he's referring to reasoning which doesn't properly apply to the exercise of the discretion. And you may be able to say he should have considered all those questions afresh there. But at the moment, it seems to me what he did was he considered proportionality in great depth on the A1-P1 basis, on the sort of provisional basis that he was wrong about the application of A1-P1, and then dealt very shortly with your ground on rationality.
Well, our submission, my lord, is first of all, he did not deal in great detail with proportionality, and I'll come on to show that that is the case.
Well, great detail or not, he dealt with it.
He dealt with it.
You know, one by one.
But what he doesn't do is deal with, other than in that paragraph 95 that you've seen, in very summary terms, he does not explain, in other words, why it is that despite his findings of fact, that Dana Astra is only carrying on business in the construction sector in the sense that all the factors you have heard me outline and summarise, and all the factors that the judge found to be correct as a matter of fact, that it has no choice. He has not dealt with why then this is a rational exercise of the Secretary of State's discretion to sanction somebody as if it were correct that they were in fact obtaining a benefit from the Government of Belarus. So Dana Astra's entire case on the facts is, how can you, yes, we tick the box because so does almost everyone, but how can it reasonably be said that somebody who is only in that project because it is forced to and has requested that it divest itself but can't, how is that to be said to be benefiting from the Government of Belarus when the opposite is true? And the answer to that question that the government gives is, and the judge gave in my submission, was you don't get to go there at all because of that provision in the regulations which says benefiting from the government means carrying on business, that you go no further than that. You're just not allowed to look at the facts. All you do is you say, if we're carrying on business, therefore you are benefiting from the government, and we will be entirely blind to all the facts suggesting that exactly the opposite is true, that we are plainly not benefiting from the government. We are, as the judge correctly found, seriously suffering at the hands of the government.
Well, you know, taking my simplistic view of this, you have in your grounds of appeal raised the point about the facts and the facts being relevant to rationality, because you say in ground 3 under rationality that he concluded that the appellant's domestic public law rationality challenge was dismissed for the same reasons as he provided in respect of HRA proportionality. But in fact, that's not entirely true, puts too much probably on the word parasitic, but it is at least one arguable reason that he gave, and you challenge it for all the same reasons as are in ground 2, one of which is that the facts were relevant. So I think it is open to you to make these points. It would help me if you would also say why you say, if you do say, even though it's not a specific ground, why you say he was wrong in 95 in what about setting out the reasons. Because he seems to have understood your rationality challenge as merely being that it was irrational, because he says, you see, at 95, he, just going back to it.
He simply says rational reasons were given for the designation.
Exactly.
And he seems to be saying that it is not open to us to suggest that we don't benefit from the government, having accepted that the box was ticked. That was...
He seems to be saying it's not irrational if you give reasons.
But your, as I understand it, lack of reasons was not the only way in which you put your rationality.
We weren't suggesting there was a lack of reasons.
No,
we were saying it was
Wednesbury
vanilla
unreasonable.
proportionality and Wednesbury unreasonable to sanction somebody for benefiting from a government when the government has a gun to their head.
Yeah.
And particularly in our...
If I may say so, Ms. Lester, you keep rewriting the regulations. What your client is an involved person, if it is or has been involved in obtaining a benefit from or supporting the government of Belarus through carrying on relevant business activity, that is the constructions, is or has been obtaining a benefit from or supporting. And you keep saying your company has now fallen out with the regime, or the regime is doing oppressive things to it now. I think Sir James's reply, no doubt much more elegantly, will be so what?
It may well be so what, and we say that is the same error that the judge made to say so what. The so what is of central importance to the exercise of discretion. The government has a discretion which it must exercise reasonably as to whether to designate my client. My client is within the net of potential people it could consider whether to designate for the reasons your lordship gave, because it's carrying on business. At that point, the fact that it is carrying on business in the construction sector ends its relevance. It's done its job. It did its deeming. You are deemed to support the government if you carry on business in the construction sector. But you park that at the ticking box exercise of are you an involved person. You then come on to how can the government rationally decide in the exercise of its discretion. Stage 2, that I quoted Mr. Justice Jay and Synesis saying it's very important there are these 2 stages. Stage 2, how is it possible, and we say it simply isn't, for the government rationally to say we're now able to consider whether to designate you. These regulations are trying to put pressure on the government of Belarus. We are going to suggest, contrary to the facts, that you are benefiting from the government of Belarus, even though we know you're not. And we say that is simply irrational. You've got to look at the facts. The government had to equip itself. It has basic duties of inquiry, has to look at the facts, not be blind to them on the basis that a part of the regulations that doesn't apply to Regulation 5, the exercise of its discretion, somehow prevents it from looking at the basic facts. Is my answer clear or not particularly?
See, I think your problem, perhaps I understand where my lord is coming from, but you have to show not that the decision was unreasonable, that's not the rationality test, it's an irrational decision, or that they took into account things that they ought not to have taken account that were irrelevant, or failed to take into account things that they ought to have taken into account that were relevant. And I, for one anyway, completely understand your first submission, which is that on this subject, in relation to this exercise of discretion, it is relevant to look at the facts, because the facts might tell you that despite the fact that you've satisfied the threshold condition, in fact, it was irrational in the public law meaning of that term, Wednesbury irrational, and we all know what that means, supposed to anyway. It was Wednesbury irrational for them to have decided that you should be sanctioned, notwithstanding that the threshold was reached. Now, it seems to me that argument was open to you below, may or may not be open to you here, but let's assume it is. But it's a very high threshold, because they said this is a huge company operating in Belarus. The judge said it's locked in the way you say. It's being badly treated by the government of Belarus, now being, as it sees it, badly treated by the government of the UK as well. And it's in a bind. It's in caught between a rock and a hard place, as we might say in vernacular. But does that make the decision to sanction it? How can that make? Why does that make the decision to sanction it irrational when you look at the reasons which are set out, the final reasons given at paragraph 25 of the judge's judgment, where he says, we're sanctioning this person because it's an involved person, which is true. It's been involved in the repression of civil society or democratic opposition in Belarus as a sponsor of BNOC. Well, that's correct factually. It ceased to be, but it was involved, as my lord has, I think, pointed out. And it is or has been involved in obtaining a benefit through carrying on business in a sector of strategic significance, which seems factually correct. So the government's reasoning for sanctioning you is that you've passed the threshold, and as a matter of fact, those threshold facts exist as well. So they're using that as to justify the discretion. Now, why is that? My question really is, why is that irrational as opposed to just something you don't like, when the government thinks that apparently has taken the view, and it's not for this court, we can come on to second guessing government and margins of appreciation and all that stuff. We can get, we can go on for weeks about that. But why is it irrational to have exercised that discretion on that factual basis, even if you disagree with the decision?
Two reasons, my lord. First of all, the government simply never considered that question at all. If you look at the SDF, that's the Sanctions Designation Form, and the documents that we put in, I'll show in a moment, in the administrative review process, the government considers two questions, and only two questions.
Yeah.
Do you tick the box of involved person? And if there is jurisdiction for ECHR purposes, is it proportionate? They are not, the Secretary of State is not directed to and never considers whether it is rational to exercise its discretion to sanction Dana Astra on the facts, and I will show you that. The second answer to your Lordship's question is that I took you to the statement of reasons for sanctioning my client at the beginning. I'm going to come on to the Olympic sponsorship reason now. But on the carrying on business reason, the reason my client is sanctioned is that it is involved in obtaining a benefit from or supporting the government. Now we say, if it's going to sanction us for currently obtaining a benefit from the government or supporting the government, there has to be a rational factual basis for that.
Well, there is a rational factual basis. It was involved in obtaining a benefit because it entered into a massive contract to build some massive centre, and it's now still doing so.
So we are not suggesting that we could have brought this challenge years and years ago when that could have been suggested. The government's case is that Dana Astra is...
Well, it says is or has been.
No, on the statement of reasons, with respect, my lord, in the SDF, that's the public statement of reasons for designating Dana Astra.
What's the date?
Page 48.
What's the date of this form?
August 2023. That's tab 3 of the supplemental bundle.
Sorry, tell me the page.
48. Dana Astra is involved in obtaining a benefit. So it is obtaining a benefit from or supporting the government. That is the case against my client. The judge has found, and I've given...
Sorry, because I do want to find out whether the judge wrongly recorded it, because I see in the UK statement of reasons Dana Astra is involved in obtaining a benefit through carrying on business in a sector of strategic importance. But I see in the judge's recitation of the statement of reasons, the amended statement of reasons of paragraph 25, is or has been involved.
So certainly the criterion in the regulations permit that, but that's not the statement.
But that's what the judge says are the reasons. The amended statement of reasons provides as follows. Dana Holdings, aka Dana Astra, is an involved person under the Republic of Belarus, etc. And then he gets that wrong, does he?
Well, yes.
Hmm?
He says
The
is or has.
statement of reasons is an involved person because one has been involved in repression of civil society.
Yes.
Name is a sponsor of the Olympic Committee and is involved carrying on business.
Yes, but when he cites it
He
at
misquotes
25, he gets it wrong.
Yes.
25-2, because he says or has been.
That's right.
And that's incorrect.
That is incorrect. You've got the statement of reasons in the
Right,
bundle.
and then he says, I'm sorry to do this, it seems to me important, so that's why I'm asking. In 26, he says, in more detail, the updated SDF and the administrative review form explained the two grounds of designation, and under the second, I don't know which page that's at, but you'll tell me.
The review form.
The one, what he's referring to at paragraph 26 of his judgment.
The administrative review form is in the core bundle at tab 7, page 129.
C129.
That's the letter attaching it, and the administrative review form starts at 132.
122.
132.
But I've got an.
I hesitate to rise, but just in case it assists the court, I think the typo is in the review form that my learned friend has gone to. But actually, if you look at the designation that's published,
Which page is it?
it's not in the bundle, it's in the bundle below, which is where the court must have got it from. But the actual published document and what would have gone to my learned friend's client makes it very clear that it is or has been involved in.
Right, and which page is the document referred to in paragraph 26 of the judge's judgment?
I don't think it's in your bundle.
What, the administrative review form and updated SDF is not in my bundle?
That's the document I was showing.
That is the document that you were shown, but I think the court may have taken it from the witness statement.
No, I don't think it is the document I was shown. But you said it was at 132 in the core bundle, but 132 is paragraph 68 of somebody's witness statement. So in the core bundle, so I just want to know 132 of the supplementary. That's what you're
The core
referring.
bundle.
Oh, 132.
My 132 of the core bundle is
It's
the administrative review form.
Right, not
And my
mine.
48 of the supplemental bundle is the sanctions designation form. That sets out the reasons, and it says UK statement of reasons, and it's very clear on that point.
I'm sorry, I haven't got the same core bundle as you.
Do you have the supplemental bundle?
Yes,
And do you have at page 48 the sanctions designation form?
yes.
And do you have at the bottom of page 48 the UK statement of reasons?
Yes, I've got that. And that is where I identified an error, because the UK Statement of Reasons does not accord with paragraph 25 in the judge's judgment, where I had previously been taking the reasons. Right, there is an error. Mr. Pobjoy has explained that that error is comes from the Statement of Reasons, and that when the Statement of Reasons was published, it included the words or has been, and so the judge must have got it from somewhere else. But I then was asking you, I'm sorry to be so laborious, but I do need to know the answer to these questions. Where do we find what he refers to in his judgment of paragraph 26, namely the administrative review form and updated SDF? And
But the updated SDF is the document I've just referred to.
right, where is the administrative review form
Well,
that talks about the first ground of designation arises from, etc.?
Mine is 132 of the core, not the supplemental bundle, so not the same bundle.
Is 132 of the core?
It is.
Right,
And
not
the
in
relevant
mine.
page is 143.
Sorry?
The relevant page is 143.
Of
Within, it's the same
core bundle.
document.
143.
Yes.
Let me
That's
just see.
internal page 12 of the same document.
Right. Yes, 143 is the ground for revocation. I have. And page 143 is a document seeking revocation of sanctions. It is not the administrative, oh I see, it may be the administrative review form.
That's where the government responds to the revocation request.
Right, okay. Got it now, thank you.
But the designation form that contains the is the form that is sent to our client explaining the reasons for the designation.
And where's that?
The one that I've shown your lordship at page 48 to the supplemental
Statement of
bundle.
reasons.
Yes.
That's it.
That is the reasons that were sent to my client to explain the designation.
Okay,
It sounds
so,
like there are different
Mr.
versions.
Popjar, have you got
Sorry
that?
to write, but the letter that was sent is actually at 129 and 130, and it clearly has is or has
129 of,
of the core same bundle, the core bundle.
well, you say that, but at 129 of the core bundle, I have paragraphs 60 to 61 of the Secretary of State's skeleton argument in the administrative court.
I think you may be working from a different bundle.
Yeah, because I've got the letter dated the
Yes.
31st of August.
Right, and I need to be given the correct bundle. Maybe my JA can send me the correct core bundle, because I've obviously got a wrong one. I will close it down and he'll send me one. Okay, but anyway, you say that the original letter says or has been, and this letter says it doesn't.
As does 143, which is the administrative review form.
Right, okay, thank you.
So if we're looking at what the government's reasons are, it is very clear we say that it is. And I say that because if your lordship looks at the sanctions designation form, which sets out the reasoning, on page 59 of the supplemental bundle, at the top of page 59, on this basis there are reasonable grounds to suspect that Dana is involved in obtaining a benefit from or supporting the Government of Belarus through carrying on business in a sector of strategic significance. The next two paragraphs then go on to suggest that actually the restrictions don't have that much impact as we have suggested they did. So if you look at the last paragraph of that page and the last sentence, we do not consider other requirements such as the approval of the ministry to significantly impact on Dana Astra's carrying on business. Now the judge made findings of fact that are contrary to the Secretary of State's analysis there. So the judge's findings of fact you will find in the judgment at paragraph 21, page 83. And if I can show you that, he rejects the government's analysis and is very clear about this. Last sentence of paragraph 21. I am satisfied that the consequences of the Belarusian sanctions for Dana have been severe. In short, Dana faces real challenges in operating effectively in Belarus. It is unable to divest itself from the project, and it has been threatened with and recently subject to expropriation. Although he says the Secretary of State does not take issue with these matters, I suspect that the answer is the Secretary of State does, and the judge is not in agreement with the analysis set out at paragraph 59.
Can I just ask you this? I get all that. Why, simply because Dana is doing business but facing really uphill struggles and difficulties, which I imagine a lot of people doing business in Belarus may face, why does that mean that it is irrational to say that it is, as well as has been, involved in obtaining a benefit through carrying on business. Because what I'm asking is, it's perfectly obvious it is carrying on business against all the odds. You may not want to, it may be locked in, but it is. And so why does it make it irrational to say that you would exercise the discretion to sanction this person who is intimately involved in carrying on business, despite facing all these hurdles?
Because the reason for sanctioning them is that they're benefiting from the government or supporting the government. It's not because they're carrying on business. It's because they are said to support the government and benefit from the government. And that the whole of our case...
But it's not what it says. It says involved in obtaining a benefit from or supporting the government through carrying on business. So the key element of that is carrying on business.
But, my lord, that's why I made my submissions earlier. We don't accept that. The only relevance of carrying on business is that it deems you under the regulation, if you're carrying on business, for the tick box exercise of involved person.
I accept that point, Ms. Lester. For the sake of argument, I don't accept anything finally, but I entirely accept that the deeming is finished. That's stage one. But the government is saying that at stage two, it thinks that the reason for exercising its discretion against you is the same reason as it gets it over the hurdle. And the reason is that you are, or have been, doesn't really matter because you actually are anyway, continuing to do this, you are involved in obtaining a benefit from the Government of Belarus through carrying on business in a sector of strategic importance. Now, it seems to me that you have to accept that that's what's happening factually, however unwilling a participant you are. And well, the first question is, do you accept that? The second question is, if that is correct, that however unwillingly you are carrying on business with the Government of Belarus and thereby obtaining a benefit in some form, because business is trade and they presumably get paid for what they do in some form or shape. If that's the case, then why is it irrational to exercise the sanction discretion?
That the factual premise of what your lordship said is not, with respect, correct.
Right.
We do accept that we're carrying on business just because we're forced to carry on business. We've applied to divest and we're not allowed to.
So let me just
We
note
do
this
not
down. We accept that we are carrying on business because we're forced to.
Yes. And therefore we accept we tick the box for being an involved person. We do not accept, and we deny in the strongest possible terms, that we benefit from the Belarus government. See the wealth of evidence showing that we are targeted by the Belarus government for all sorts of unpleasant consequences, including corporate raids, arrests, detentions, and so on. So there is no factually real-world sense in which we benefit, or could rationally be said to benefit now from the Government of Belarus, or support it. And just carrying on business in a sector of strategic significance is not enough to show that we are, which is the government's case.
But isn't that getting into a sort of value judgment argument?
It's getting into the facts, my lord, but that is exactly what the exercise of this discretion requires.
I mean, rationality. I mean, what as I sort of understand rationality to mean is that, and if you were right, that you weren't obtaining a benefit through carrying on business at all, then it might be irrational to say you were, right? But how do you judge those things except by getting into the kind of analysis that is really beyond rationality?
So, two answers, my lord. First point, the government has not considered the exercise of that discretion at all. And I did say I'd show it to you, and I will. They consider the tick box involved person and rationality and proportionality. They do not consider the exercise of the discretion. I'll show you that now. My second point is this. Take an example. Let's suppose somebody is still carrying on business in the transport sector. Right? Let's say they are involved in working on the trains in Russia, but they're sitting in a gulag. Now, on the judge's approach, or we suggest the judge's approach and the government's approach, the regulations mean that that person cannot say it's irrational to sanction me for benefiting from the government of Russia, even though they lock me up. So, for example, take Navalny, take Khodorkovsky. All of these people are involved persons.
Well, let's not take people. Let's take your example. It's a good example, it seems to me. Mr. X worked on the transport, on the trains, serving coffee, and for 10 years. So the hurdle is passed because he obtained a benefit from carrying on business in the transport industry, and is now locked up in the gulag as an opponent of the government. Theoretically passes hurdle 1. Question, can you rationally exercise the discretion to sanction that person?
On the grounds that he's benefiting from or supporting the government.
Well, on the grounds even that he has benefited from.
Yes.
Now, I think, well, we'll have to ask Sir James what he says about that, but I think Sir James might say, the legislation allows you, having passed hurdle 1, to impose sanctions, and you have to show that it would be completely irrational to do so because you could not possibly achieve any objective of imposing sanctions by doing so. And in your example, you might have quite a good case, I hazard. We'll ask what Sir James thinks. But that's not this case, is it?
What we say effectively is this case.
You say it is.
Same thing, exactly the same thing.
Okay, well, I get it.
Obviously, we're not in a gulag, but we're in a business.
No, but I see what you say.
What do you say about the findings about the sponsorship of the Olympic Committee?
I'm coming to
You
that.
say that's all past history.
Well, we say a number of things about that. So the concern about, so this is a different criterion for listing. Sorry, should I just show you first, before I forget, that the government has never considered the exercise of the discretion?
Please. Yeah.
Just to give you the references at least. From the administrative review, the internal government review that's conducted, this is in the supplemental bundle, tab 10, if you have tabs, page 197. Do you have a 197 to the supplemental bundle?
No, not in mine.
Yes.
Yes? So that is the, my Lord Justice Foster's not, is that right? No.
197, yeah, I have got it. Yeah.
You have, okay. So 196 shows that this was a meeting on the 16th of August 2023, that's shortly before designation, in the FCDO's Sanctions Directorate, considering what recommendations would be made in relation to this listing. And I just want to show you paragraph 4. Following discussion, the panel concluded that Dana satisfies the legal test reasonable grounds to suspect that he was an involved person, and the designation continued to be proportionate. So no consideration there of the exercise of that all-important second question. And then if you look in the SDF, that's where the, as it were, official reasons are given for the now public designation. That's tab 3 of the supplemental bundle. You've seen this a lot, page 48. You will see that part 2 of that document, which starts at page 51, is the designation criteria. So that is the box ticked and why they think the box is ticked. Part 3, which starts on page 60, is ECHR compatibility and proportionality. So there is no consideration of whether it is rational to exercise the power in section 5 to designate.
Well, no consideration, I mean, that's again confusing a lot of terms. No, the government doesn't have to go and ask itself if it's rational to do it. It has to ask itself whether it should exercise its discretion. the statutory hurdle having
Indeed.
been passed.
Well, it hasn't
And-
done that.
And you say it hasn't done that, but it has, because it's decided on the same grounds as allowed it to pass the hurdle that it should exercise the discretion. Now, that may not be enough, you may be right.
But we don't know that, my
It
lord,
may be
because
irrational.
they haven't. The Secretary of State has not said. I now come on to considering my power under Regulation 5,
Well,
and I have decided.
he uses the term proportional. You see, this is the
Well,
terrible thing
that's a
about...
different point. Proportionality is
No,
the
no.
Bank Mellat test.
I know, but when we look at this document you just showed me,
Yes.
paragraph 4, of page 197, we see that it uses the term proportionality apparently to be the next stage of whether it should do what it's done. And obviously that's wrong for the reasons we discussed earlier. The word is not the right word. But it seems that it is simply exercising the discretion to impose sanctions on the same basis as the crossing of the statutory hurdle.
But
Now, that may be good for you because you may say that's not good enough.
If the government had said that, we would certainly say that's not good enough.
Yeah,
In
no,
fact, they've
that's
said
fine,
nothing
but that's
at
what
all
it
about
seems
it.
to be saying.
In
It
fact,
doesn't
they-
seem to be going any further except in what the judge recorded at paragraph 26.
Can I move on to sponsorship?
Yeah.
I'm a little aware of time. So the concern about the repression of democratic opposition arose in the aftermath, you've seen this, of the elections in Belarus in August 2020 and the crackdown by the government that followed. And you may have seen from the Synesis case, which was the one at tab 22, an example of a listing made on that basis. Synesis was sanctioned for supplying technology to the government for use in the video surveillance and monitoring system that was used by the Belarus Ministry of Internal Affairs to track down protesters who were then beaten and tortured. That was the evidence. And a challenge in that case was made to whether there were reasonable grounds to suspect that Synesis was involved. And perhaps unsurprisingly, Mr. Justice Jay found that the Secretary of State had properly evaluated the evidence and was entitled to reach the conclusion there that there were reasonable grounds to suspect involvement in the repression of civil society and democratic opposition. Now, the concern about the Belarus Olympic Committee in the context of that crackdown was that after the election in September and October 2020, hundreds of athletes protested about the elections and faced serious reprisals by the government for doing so. The International Olympic Committee investigated those claims, and in December 2020, it found that the National Olympic Committee had not appropriately protected the athletes and imposed provisional measures. Now, the Secretary of State's case is that it has reasonable grounds to suspect that through its sponsorship of that National Olympic Committee, Dana Astra was itself involved in the repression of civil society and democratic opposition. And in the SDF, the document we just looked at, they say Dana Astra was complicit in the repression. And that is because Dana Astra's sponsorship agreement with the Belarus National Olympic Committee continued up until January 2021, after the International Olympic Committee had imposed provisional measures. And on this reason, we challenged both there being reasonable grounds to suspect that Dana Astra is an involved person and the exercise of the discretion. Now, we say, first of all, that the judge made the same error in relation to this reason as the previous reason. In other words, he says, we simply cannot argue, well, this is our understanding of the judgment, we cannot argue that we have not, in fact, enabled or facilitated repression factually because we're an involved person and we tick that box, end of story. And that, I've already made my submission as to why we say that is incorrect. But that led him, we say, to exclude from his analysis the key reason that this, we say, is an irrational, and I'll come on to a disproportionate decision, because the material before the Secretary of State showed that Dana Astra had a sponsorship agreement and it stayed in place till January 2021. If that's all it showed, we would clearly have no case. But the material before the Secretary of State showed that Dana Astra first took all steps it could to terminate the sponsorship agreement precisely in order to distance itself from the National Olympic Committee as soon as the International Olympic Committee found that the NOC had supported the President's crackdown. Second, that Dana Astra was the only company that did so. Many other companies, including Coca-Cola, continued their sponsorship. Dana Astra uniquely took steps to distance itself. And third, that the majority of Dana Astra's employees were in fact pro-opposition and had been part of the anti-Lukashenko protests after the elections, and that Dana Astra had supported them. Now, I can show you that quickly. The material is in the Sanctions Review request form, which is at tab 2 of the supplementary bundle. I will take this very fast. And the relevant paragraphs are at 3.6 to 3.12. And they start on page 26. Thank you. And if you just scan those, you will see that 3.6 records the sponsorship agreement. 3.7 explains that the sponsorship of NOC is normal marketing practice. Negotiations began in June 2018, well over 2 years before the presidential elections. I might add that President Lukashenko was not sanctioned in 2018. Sanctions had been lifted in 2016, so the concern arose in the aftermath of those August 2020 elections. Paragraph 3.8 records that the agreement was negotiated on standard terms regulated by the International Olympic Committee. Then at 3.9, that Dana Astra signed a termination agreement, and sentence 2, Dana Astra sought to terminate the agreement in order to distance itself from the NOC, given Dana Astra's non-political stance. The existence of an ordinary sports sponsorship agreement is no evidence that it is or has been involved in repression. Then at paragraph 3.10, you see it being said that Dana Astra is non-political. This is demonstrated by the fact that the company has never paid any regard to the political persuasions of its employees, the majority of whom are pro-opposition and include those actively protesting against the Lukashenko regime and the 2020 elections. And we've put in the bundle what the footnote 11 examples of Dana Astra employees' social media accounts showing the kinds of anti-Lukashenko protests from their employees.
The judge deals with this in some detail leading up to paragraphs 38, 39.
He does.
You just say he's wrong on the facts.
I'm coming to that. I'm sorry if I'm tiring you on this. And at 3.11, the point was made that other non-state-owned companies continued to be sponsored. So those are the facts that were before the Secretary of State. Now, when the Secretary of State analysed this material in the sanctions designation form, it made, bearing in mind the standards of decision-making in normal public law decision-making, they made no mention of Dana Astra seeking to terminate the contract as soon as they were able to do so. Now that is a point of central relevance, we say, to the analysis. Yes, there was a sponsorship agreement, but as soon as the concern was raised about reprisals, Dana Astra wrote seeking to terminate it. No consideration in the SDF by the Secretary of State. Secretary of State did consider the evidence about workers striking, but reached the conclusion simply that that didn't detract from the fact that we had a sponsorship agreement. But that is obviously not the point that was being made to the Secretary of State. And the third point made by the government was that they were unclear as to whether there was any form of sponsorship still in place. So they were unclear on that key point, but they never sought to make reasonable inquiry on that point. Now, I will show you simply the reference to where I'm taking that from is in the SDF, and it starts with their conclusion on page 10. I won't take you through it for reasons of time, but I've made my points about that. No mention at all of the point of central relevance that Dana Astra uniquely sought to terminate the sponsorship agreement as soon as it could. Now, when we were sent the SDF, when my client saw for the first time that it was being suggested that the government was not clear on whether there was still any sponsorship in place, we addressed it as soon as we could, which was in the Samler challenge before the court. And the judge summarised this at paragraph 20 of the judgment. And he summarised there the evidence in about the fourth sentence. Mr. Mulich says that Dana sought to terminate the agreement in order to distance itself from the actions of BNOC, which it considered to be at risk of tarnishing Dana's name. And the company sought to do so as soon as reasonably possible following the IOC's findings. I won't show you the witness statement, but Mr. Mulich's statement is at tab 5, page 75. He makes clear, first of all, that Dana Astra could not unilaterally terminate the sponsorship agreement. It had to seek the agreement of the NOC. It sought to do this as soon as it could. Since then, no parts of the sponsorship deal have been still alive. And moreover, when Dana Astra saw that its logo was still on the NOC's website after it sent notice to terminate, it sent 4 follow-up letters, which are also in the bundle, repeatedly asking for its name to be taken down to make sure it had no association at all with the NOC. And we say in those circumstances that there was simply no rational basis for sanctions to be imposed on the grounds that they are complicit in, involved in the crackdown. Mr. Darling's statement, then Deputy Director in the FCDO's Sanctions Directorate, also says nothing about this. He simply says sponsorship remained in place. Nothing at all about the obviously central relevant fact that Dana Astra had been taking active steps to distance itself from the NOC. Simply blind to that. Now, the basis on which this was put to ministers in that meeting of the 16th of August said that there was strong evidence reaffirming Dana Astra being involved in the repression of civil society. They don't say what evidence there was. The correct position is that the government were unclear on the key point but had not sought to clarify it. The decision maker was told nothing about the key points showing that far from being complicit in repression, that Dana Astra's workers were striking against Lukashenko, had been allowed to do so. Others were continuing to sponsor, while Dana Astra uniquely sought to do the opposite. None of that is in the ministerial submission, which is in the supplemental bundle at tab 10. So why then, to my Lord Justice Bean's point, what then did the judge say as to this ground and why it was rational? So this is at paragraphs 34 to 38 of the judgment. This is page 88. So paragraph 34 is his conclusion that this was rational. Paragraphs 35 and 36 set out the background, namely the fact that there was this sponsorship agreement in place, the concern about reprisals after the elections, the investigation by the IRC. Paragraph 36 records the provisional measures. Paragraph 37 says that termination of the agreement in 2021 does not undermine the fact that we gave support to the Belarus Olympic Committee. So if you look at the middle sentence, the agreement was terminated, but that does not undermine the fact that Dana gave public-facing apparent support to BNOC through sponsorship of the state and the BNOC which carried out abuses. We say, with respect, yes, it does. When the IOC said that the Belarus Olympic Committee had been repressive, we terminated our agreement. We sent follow-up letters. No other company did this. That is simply not consistent with those findings. Then he said that the apparent distancing was not something the Secretary of State was obliged to accept, removed support by sponsorship. But with respect, that is not the question. What the Secretary of State was obliged to do was gather and evaluate the material on this point and reach a rational conclusion. And the judge never reviewed that. So that's why we maintain that this also was an irrational decision. Now, moving briefly to proportionality, and then I will let Mr. Birdling make his submissions. We also say, subject to the point about jurisdiction, that Dana Astra's designation was a disproportionate restriction on its A1P1 rights. I've already made my point about the key error in relation to the proportionality analysis at paragraphs 80 and 81. The judge simply did not allow in the key facts on proportionality on both the Olympic ground and the carrying on business ground. Now, we say it was obviously of central relevance to a proportionality analysis properly undertaken that Dana Astra stopped its sponsorship as soon as it could, precisely so that it was not complicit in the repression of democracy. So the opposite is true. Second, it was obviously of central relevance to a proportionality analysis that we were only carrying on business because, as I put it colloquially, we had a gun to our head. And the fact that he simply said those were not arguments open to us at all, paragraphs 80 and 81 of the judgment, shows with respect, we say that the court simply did not properly perform the analysis of proportionality. And as you will hear from Mr. Birdling, that the court, this court as an appellate court, must do so again itself, and that that is clear from the Supreme Court's judgment in Spidler, but I will not say more about that. Now, the Secretary of State's answer to this is to say, well, the judge weighed up the facts anyway in its proportionality analysis, but that is simply not right. It didn't weigh the facts on this at all in the proportionality analysis. The judge made findings of fact that Dana Astra could not operate effectively in Belarus, could not divest itself. In other words, it couldn't exit the market and was subject to expropriation by the state, but did not take that into account in the proportionality analysis. And we've set that out at paragraph 49 of our skeleton argument. At paragraph 82, the judge said in relation to the Olympic, in relation to carrying on business, that Dana Astra was not singled out as a company by the government of Belarus, and other companies were also subject to similar measures. But again, that simply is not the relevant question. It's not relevant whether Dana Astra is uniquely singled out, or other companies may or may not also be subject to similar repressive measures. The issue is whether sanctioning Dana Astra for benefiting from the government, given its position now in Belarus vis-à-vis the government, is reasonable and in this section proportionate on the basis of all the material. And that includes, is it capable of contributing to the aims of the measures, on which we say the evidence was clear, but the judge simply said we may not rely on it because of what we respectfully submit was a misconstruction of those deeming provisions in the regulations. We say in any event the documents are clear that we were singled out and that the unfriendly behaviour of which we are accused is not just foreign ownership, but missing deadlines and so on. But we don't have time for that now. And I have already showed you the errors in relation to the weighing up of the facts on the Olympic sponsorship deal, that he simply ignored the evidence, which we have summarised at paragraph 51 of our skeleton. So properly looked at, we say the designation has no rational connection with the objectives of the measures. It simply cannot contribute to the desired objective. In relation to carrying on business in the construction sector, the government's case on rational connection is that designation sends a signal that Dana Astra supports and benefits from the government, that is unacceptable, that Dana Astra must be held to account, and that the designation will incentive behaviour change. But we say with respect, this is simply incoherent. What behaviour is Dana Astra being held to account for when the facts are properly looked at? And there is a clear finding of fact that it cannot change its behaviour. It is not permitted to exit the market. as regards the Olympic sponsorship deal, the government says this sends a signal that Dana Astra is complicit in repression in the aftermath of the elections, that its conduct then was unacceptable, it must be held to account, and again that it will incentivise it to change its behaviour. But all the evidence goes the other way. When it's looked at properly and not fettered in the way that the judge fettered this analysis, it stopped sponsoring as soon as it could. The signal sent is that the one company that distanced itself is sanctioned and the others are not. And again, what behaviour change? What more could Dana Astra do than it's already done? This is nowhere explained. Can I just take the final points from my skeleton argument just to speed things up? At paragraph 53 and 54, we have summarised the key errors in relation to rational connection. I'm not going to repeat them there, but you'll see it under subsection 1, the errors in relation to these signalling or messaging effects given the facts. And at subsection 2, the key errors in relation to providing incentives, that's the changed behaviour point. And I draw the court's attention on page 38 of our skeleton argument, that's paragraph 53 1e, a further point that we have made, that all that remains, we say, is a wish to signal the Secretary of State's retrospective disapproval of the appellant ever having involved itself in the Belarusian construction sector or with the BNOC in the first place. But we say sanctions cannot properly be imposed as penalties for past conduct. Not only is this not permitted, as it would infringe non-retrospective penalisation, it is wrong in principle to allow sanctions to be justified as a punishment purely for past conduct. We have also set out in our skeleton argument the points we made in relation to arbitrariness at paragraphs 54, 55, and in relation to less intrusive measures at 57 and fair balance at 59. And if you are content to read those from my skeleton argument, that would be helpful given the time. But with your permission, if Mr. Birdling could take over.
Yes, by all means. Thank you. Mr. Birdling.
My lord to my lady, I'm going to deal, as Ms. Lester indicated, with 2 points. First, I'm going to take very shortly, and that is what we say, assuming you're with me, on jurisdiction to the approached proportionality in light of Schvidler. Now, I know my lord the Master of the Rolls and myself and Sir James had this discussion in Schvidler, and
Not only in Schvidler, we had it again last week. Probably, judging by the chances, it'll be next week as well.
Well, for reasons that the court will know from the judgment, the Supreme Court decided not to adopt the hard-edged typology that this court suggested to the issue, and so we're left with something more soft-edged. Our primary submission on this side is that there were errors of approach that were made by the judge in particular.
Yeah, I mean, if there were errors of approach made by the judge, plainly we do it again. If there were not, then it's for discussion whether this is the type of important case. This is not the first sanctions case.
It's not.
We've been through this at the highest level in the Supreme Court and in this court. So arguably, if we were not satisfied there were errors, why should we not simply say that the judge has done it once and that's enough?
Well, what I say to that is that when one looks at the factors, and this is paragraph 162 of the judgment of majority.
162 in
162 in
Schvidler.
Schvidler. It's at tab 25 of the authorities bundle, page 1636.
Sorry, which page in the authorities?
It's 1636.
136.
Sorry, 1636.
1636.
So paragraph 162, there's a rather large list of factors that one considers. And what it boils down to here, in my submission to encapsulate, is that your Lordship's right, that this court won't be reinventing the wheel in terms of what the big picture issues are in terms of deference, etc. So those questions of approach, one now has settled. But what one has uniquely in this case, not in any other case that's come before this court or the Supreme Court, is that we're dealing with, as we'll come on to discuss when we look at jurisdiction, issues about a company that is out with the jurisdiction in a physical sense, and we're going to come on to discuss the relevance of that shortly. But how one, assuming you're with me on jurisdiction, and there is a proportionality analysis for the court, the lower courts will need to have guidance as to how one approaches that exercise, how one balances things in those particular circumstances where you have a company. And the same is true for an individual, because some 95% or so of designations relate to individuals or companies that are outside the physical territorial jurisdiction of a member state. How one approaches that exercise. And that is a different exercise to the one that the court was looking at in Schvidler. The one was dealing with a boat, detention of a particular chattel in respect of the corporate entity, and an individual who was within the UK in respect of Mr. Schvidler. So when one asks, and this is what I say it really boils down to, paragraph 162, is that bearing in mind this court has an important role in setting effectively guidance or guidelines for lower courts that they can look to and say, well, how we to strike the balance. They are going to be much better served by knowing what the Court of Appeal thought itself about proportionality and how one strikes that balance than the court saying, we thought Mr. Justice Saini did a job that fell within the guide rails, as it were, no obvious error of approach in terms of the broad principles. That is what I say about that. And I suspect, really, whether it's an exercise you undertake for yourself, whether you even reach this point will depend on the view you take on our ground one, the jurisdiction point. But I do say, if you are with me on ground one, and we are into proportionality, Human Rights Act proportionality, then we really are in the territory where the lower court will benefit from this court's view on that exercise. That's what I say. I'll hear what Sir James says, and I can come back to that in reply, but that's all I want to say now. I do say that for the same reasons the court said, the Supreme Court said in Schvidler, if you're with me on...
Now, I can see that if you're right about Article 1, and A1P1 is engaged for a company outside the jurisdiction, like Dana, without assets in the jurisdiction, arguably at least one can see that it is a different situation from Schvidler, and Schvidler might point in the direction of having this court's own view as to proportionality.
That's what I say.
That's what you say.
And the court won't reach, if I'm wrong about jurisdiction, then the court won't be worried about proportionality anyway, save unless it's
Exactly.
expressing its views in case it goes higher. But that's what I say about that.
Before we leave proportionality and Schvidler, can we get any guidance from the outcome of Schvidler?
Yes.
And I mean specifically Schvidler rather than Dalston Properties. Mr. Schvidler, British citizen, British resident, subject to sanctions which effectively froze his assets. His children had to be taken out of public school. I think eventually he left the country. And yet, 4 of the 5 members of the Supreme Court said that was not disproportionate.
Well, my lord, again, that when one is making proportionality assessment, this is why I say it is quite important to have this court's view rather than a franking of the effectively rationality of the lower court's overall assessment. What that involved, the Supreme Court weighing up on the one hand what your lordships just alluded to, the very real and accepted harms, but on the other hand, the contribution that it had determined or it had ascertained by reference to the facts that particular designation was going to make, bearing in mind what was said by the Secretary of State about Mr. Schwidner's association with Mr. Abramovich and how that might influence levers of power. Now that is qualitatively different to what you have here in this case, whereas Ms. Lester's just explained to you what is said is, you've ticked a box, so you have been involved, or are involved in these particular activities, and that by itself is sufficient. So a lower court is going to want to know, well, does the Court of Appeal, does this court think that that is sufficient on the other side of the ledger if it were conducting that proportionality exercise? And for precisely the same reasons that your lordship has suggested that this court might get some assistance from the Supreme Court in Schwidler, I say it doesn't because of those differences. A lower court knowing that this court, aware of those differences, having heard the argument about it, itself struck the balance in a particular way. It's precisely the sort of situation that the Supreme Court was saying it is appropriate in terms of constitutional role of an appellate court, institutional competence, etc. And as I do say in particular, giving guidance to the lower courts. So I say that you don't, the Supreme Court in Schwidler, as I accept it, in answer to a question from the Master of the Rolls, of course it answers those big question issues in terms of difference. We're not reinventing those words. But what you are doing is the balancing exercise for yourself, and that is what will guide lower courts, and that is what is important for this purpose. So I'll hear what Sir James says about that, and if necessary, I can come back to that in reply. In terms of jurisdiction, to explain how this fits into the big picture, Mr. Justice Aney accepted the government's submission that you don't get into proportionality or A1E1 at all, because the Secretary of State's decision to impose sanctions on Dana Astra was not an act that was within the UK government's jurisdiction for convention purposes. That matters, obviously, because Article 1 of the convention, we'll come to see the text of it shortly when we're looking at some of the decisions, requires that contracting parties secure to everyone within their jurisdiction the rights and freedoms within the convention. So you don't even get in unless you can get through this. So the exercise of state jurisdiction is a necessary condition for the state to be held responsible in convention terms for allegations of infringement of convention rights. Now, my primary submission, as it was below, is that the imposition of targeted financial sanctions by the UK on an individual is the exercise, without more, of its jurisdiction for convention purposes. And in particular, an exercise of jurisdiction over the appellant. And that alone, we say, is sufficient to found jurisdiction for convention purposes. That's our ground.
Is that the right way of putting the question? Isn't the question whether, the primary question, whether the appellant is within the jurisdiction for the purposes of Article 1 of the Convention? It's a slightly different way of putting it.
I entirely accept that. That is how Article 1 of the Convention poses the question.
Yes, that's what I thought.
So another way of putting it is, has the UK, in fact this is a more elegant way of framing my primary submission, by designating the appellant, what the UK has done is brought the appellant within the jurisdiction of the UK for convention purposes, without more. And as the court will be aware, and as we'll come on to see, jurisdiction is primarily territorial, but it's not exclusively territorial. So it's not just that individuals that are physically within the territory of the contracting state are within its jurisdiction. We say that act of imposing targeted economic sanctions of the type that we're concerned in this case does bring the appellant within the UK's jurisdiction. If your lordships and your ladyship are not with me on that point, then our alternative case, again, here as it was below, which is our ground 1B, it is that it remains that the designation by the UK of the appellant brings the appellant within the jurisdiction of the UK, because what the government has done was intended to, and does in fact have effects on the appellant within the territorial jurisdiction of the UK. And as I will show the court, it's central, the Secretary of State's explanation as to how the appellant's designation is intended to contribute to the objectives of the regulations. That's the reason why it's active. The very intended purpose of its actions is that there will be effects on the appellant and they will be felt in this jurisdiction. I'll come on to that. But Ground 1A, our primary case, I'll start here. You've heard what the overall submission is, and I'll start here with what is common ground. And that is that the judge was correct, my respectful submission, at paragraphs 47 and 48 of the judgment, to identify the core principles as being authoritatively stated by the Grand Chamber of the Strasbourg Court in the MN and Belgian case. And unsurprisingly, the court will have seen that that case features prominently in both my main friends and our skeleton argument, that is common ground. So because of that, and I am conscious of the time, but there is in my submission a need to look at that case with some care. It's behind tab 10 of the authorities bundle. And could I ask the court please to pick it up at page 566. Foot of the page. And paragraph, sorry, that's the given a bad reference.
582 and following. That's the sideline bit.
I'm sorry, my lord. It should be page 563. I'm not sure when my reference is wrong.
Yes, that's where it begins.
Yes. So the first point to note, paragraph 8, is that the applicants in that case, who were physically located outside of Belgium, were attempting to obtain visas to enter Belgium for the purpose of making an asylum claim. And then they brought proceedings to challenge the refusal of that visa. So that is the core starting point. Then if we turn to paragraph 25, that is at page 566, you'll see that after various twists and turns, domestic tribunal, the Aliens Appeal Board, ordered the Belgian government to issue the entry visas. The Belgian government didn't, which gave rise to enforcement proceedings. This is all happening before the domestic courts. If we turn to paragraph 28, you see the Belgian state ultimately succeeded in seeing off that challenge before the Belgian appeal courts. So the factual position was that the Belgian state had never actually issued visas to the applicants, and they remained outside Belgian territory at all times. So that's the background against which it came to Strasbourg. And then if the court turns on to page 576, you'll see at paragraph 74, the appellant's applicants' substantive complaints. They allege first that the refusal of the visa exposed them to treatment that would be contrary to Article 3, and that there was also a breach of Article 6 because it wasn't possible for them to enforce the initial judgment in their favour. Government raised the preliminary objections we see over at paragraph 78, which is on page 577. complaints alleging the violations were inadmissible on the grounds that the applicants did not fall within their jurisdiction, within the meaning of Article 1 of the Convention, and the court can read the text there. That's where you find the text of it. Then the nature of that objection is set out at paragraphs 79 and 81. Don't worry about that for now, because what's critical when one turns to paragraph 96 on page 582, this is the sideline passage, is the court's reasons. So the court starts by what it describes as recapitulating the key principles. You'll see those at paragraphs 96 to 109. They'll be well known to the court and are sidelined, so I would invite the court to read those if you haven't already. But in particular 101 to 102, which makes the point I was making earlier, which is that it's primarily territorial jurisdiction under the Convention, but that's subject to exceptions. Now, for the exceptions the court is concerned with in this case, can I ask the court please to read paragraphs 107 to 109 on page 585.
Yeah.
So one doesn't get within the jurisdiction, one doesn't bring oneself within the jurisdiction of a contracting party simply by taking some act that engages the jurisdiction of the courts of that state. But what the court says, in certain specific circumstances of a procedural nature, the state might, by its own actions, create a jurisdictional link. So bringing someone within the jurisdiction of the state because the state takes some particular step.
Where are those words?
It is 107. It's the very first line of paragraph 107 at the top of the page.
Yeah.
And you see the examples given is where a member state of its own volition institutes criminal proceedings. Even though someone's outside the jurisdiction, that can bring them within the jurisdiction. The state's done something in the exercise of its jurisdiction by instituting the criminal proceedings. What we get from MN, turn on to see what won't be. This is really what's important, because the court comes on to explain what won't be sufficient by contrast to what will be. So, court turns on, please, to page 586. You see at 112, the point I just made, the fact that the Belgian authorities were exercising public power when deciding to issue a visa, determining a visa application, isn't sufficient. And I ask the court, please, to read paragraph 113 to see why the court says that's so.
And that's the critical passage you say, is it 113?
Yes, I do.
Because you say 113 says that here, well, what you say, do you, is that as a matter of fact, the respondent state has effectively exercised authority or control over Dana by sanctioning them. that what you say?
Exactly, in the respects that we identify. So jurisdiction in the convention is not a categorical concept. You can be within the jurisdiction, the contracting party for some purposes and not others. Purposes that we're concerned with here is the state responsible for the A1P1 interferences that we'll come on to in circumstances where physically located, the business is physically located outside of the jurisdiction. And I say yes, and I say we get some more help with this if you read on to the judgment, because what Mr. Justice Saini said is effectively one stops there and says, well, you're in the same category as MN. That was what the Secretary of State said, that you're not within the jurisdiction, it's purely exceptional. All you're talking about is an effect that is something that was done internally that would have effects elsewhere. That's not sufficient because you're not bringing someone within the jurisdiction. But what I say, the critical difference, and this is why I say the factual circumstances of MN were important, the reasons why the Grand Chamber said that wasn't sufficient to bring MN within the jurisdiction is that in that case, it wasn't the state that was bringing them within the jurisdiction, it was them that was positively trying to bring themselves within the jurisdiction. So you had individuals that were outside of Belgium that were making applications and representations to a contracting party saying, please bring me into your jurisdiction. And the contracting party was saying, absolutely not. Just saw they were going out of their way not to create that jurisdictional link. And that is the distinction that the court itself draws between that case and this case, where it's the court that's doing the linking. And the court will see that distinction being drawn by the court over the page on 587. And can I ask the court, please, to read that, paragraph 121 and 122, starting at the foot of page 587. Can I ask the court please to read paragraph 123 as well?
This is a very important submission, if I may say so, but you're saying really that targeted economic sanctions by any Strasbourg member state against anyone, anywhere, bring that individual within jurisdiction for Article 1 purposes.
Again, for the limited purposes of effectively here, A1P1, it's financial sanctions, it is going to be that. But yes, that is my submission, and I'll come to show the court that that was the position in the NADA case, which is another Grand Chamber decision. Different facts. But
In which one?
The NADA decision.
NADA.
NADA in Switzerland.
Yeah.
The Lake Lugano.
It is. And of course, Sir James says that that's a different case dealing with a different type of jurisdiction, but I'll come on to explain why that's wrong. But
This is the main point that's made against you in relation to NADA, that there is no explicit decision on jurisdiction because the point just wasn't examined.
well, my lady, I'll come on to that. I accept that that particular objection wasn't raised. It's effectively a Homer nodded point. But it was a Grand Chamber decision, as we'll come on to see, where the UK government intervened. And
But
the
if
French...
Homer nods, can that create a consistent line of Strasbourg authority that we're obliged to follow?
That's not my submission, my lady.
Right, okay, well that's important to be clear about.
I don't say that the Strasbourg court has ever actually dealt with this particular issue because the objection hasn't arisen. That is a point that is fairly made against me. What my submission is it's not surprising that that objection wasn't made, including by the United Kingdom government in that case where it intervened.
But the facts were really, really peculiar because there was this funny little Italian enclave that was 1.6 kilometres square, bounded on most sides by territory of Switzerland and then by Lake Lugano. So, I mean, one can see perhaps why the point wasn't taken. But the main focus of that case is whether you can attribute decisions of the UN Security Council obliging states to introduce sanctions, whether the state that imposes the sanctions can then say, well, it's not my decision, it's the UN. And that was the dispute in that case.
That was the
And
objection.
in Al-Dulimi, which followed it.
That was the objection that was actually taken, and that was what was addressed. I'll come on to take the court through both of those decisions, but so that you have my answer now. NADA, in particular, what the state said is, what the point was raised, well, actually, you could relocate elsewhere in Italy. And what the government, what the Grand Chamber said over that objection, and this was in the context of Article 8, is that no, Article 8 includes the right to your home, to respect for your home in Italy. So what the court was doing was saying, it wasn't blind to the fact this individual was territorially elsewhere, but it was holding the Swiss authorities responsible for that because it had brought that individual within their jurisdictions, an exercise of their jurisdiction. I'll come on to take your ladyship to it. But in answer to the clear and constant jurisprudence point, I say what is the clear and constant and settled jurisprudence at Grand Chamber level in all of the authorities is that this particular context-specific exception where someone brings an individual within their jurisdiction because of the exercise of authority, different from a situation where someone comes knocking at the door, that is sufficient, or can be sufficient, on a case-by-case basis, to establish jurisdiction. And I say that it's not surprising that in all of the sanctions cases, including NADA, which was an extraterritorial case, no one suggested that a state wasn't going to be responsible for the convention consequences of a sovereign act of that state intended to, positively intended to, affect the rights of an individual that was physically abroad. It's different where one's dealing with something more diffuse, where you do an act in another jurisdiction, or that you do something that occurs physically elsewhere and it has effects on that individual. Of course, that's not enough, we know that. And it's not enough that an individual tries to, by applying to your court, obtain some benefit. It's very different, and this is what the MM case is making clear, where the state in the exercise of its sovereign authority does something targeted at an individual that brings them within the jurisdiction. And I do say that is the clear and constant jurisprudence of the Strasbourg Court.
Isn't that a bit circular? Designed to bring them within the jurisdiction. That depends what you mean by bringing them within the jurisdiction.
Yes, well, the way I put it is that where a contracting party does something that creates that procedural link, to use the phrase of the Strasbourg Court, factually, that is something that the state is doing in the exercise of its sovereign powers. What you see at paragraph 123 of MM that the court just read is that the reason why it's not so when someone is asking a state to do something is that that isn't something that the state has voluntarily done as a matter of its exercise. The convention, like all international law, is about state autonomy. What Article 1 tells you is when you, within the exercise of your sovereign powers, bring someone within your jurisdiction, consciously, a choice you've made, concluding, I say,
Yeah, I mean, it's not a difficult argument. What you say is that when the convention says that the high contracting parties shall secure to everyone within their jurisdiction A1, P1 rights, a government can bring people within their jurisdiction by exercising powers over them, even though they remain outside. And that's why you emphasize that it's only partly territorial. And for my part, at least, I see that as being entirely possible. The question is whether the European Court of Human Rights has ever seen that in the same way in sanctions cases, because the ramifications of us holding this without the European Court of Human Rights having held it is that we maybe run ahead of them in a way that we would not normally want to do. What do you say about that?
well, my Lord anticipates the submission that Sir James is inevitably going to make about Alan Kane not going ahead of Strasbourg.
Yes.
And that's why I say the NADA case is particularly important.
Should we have a look at NADA? You keep on
Yes.
saying you're going to.
So it starts, well, perhaps if I finish this submission first, because it's one that Sir James is going to make, so I might as well make it, so make my submission so I can hear what Sir James says in response. But it is sanctions, the reason why you don't see lots of sanctions cases is because of the Bosphorus case, which the court may be familiar, was a European Union member state sanctions case. And what the court said is where the European Union member state is sanctioning an individual, we're going to presume that the European Union court scrutiny is sufficient for compliance with the convention, and we're not going to be analysing that for ourselves. So you only get, it's no surprise that you only really get sanctions cases involving Switzerland, cases, states that aren't part of that particular mechanism. And what the European Court does, obviously, is full factual review of all of these cases whenever they have it. So the Strasbourg Court just hasn't been presented with a wealth of cases. So if what you're looking for, if the submission is, it's surprising that actually there aren't lots of Strasbourg cases where this is all being analysed, if I'm right, is it's actually not at all surprising. There are a very small number of cases that reach the Strasbourg Court that are dealing with these designations at all. And in no case, including NADA, was entirely extraterritorial, and Al-Dalumi, where you had a company that was outside the jurisdiction, albeit with assets partially inside. In no case has the Strasbourg Court determined that that wasn't a matter before an individual within the state's jurisdiction. And the United Kingdom government, because Sir James' submission inevitably is going to be, part of it is effectively unfairness to the government, because if you decide the jurisdiction point, they don't get to go to Strasbourg, whereas we do get to go to Strasbourg and try to make this argument. So effectively knock us down domestically. If you really believe in your case, you'll go to Strasbourg. That's what it boils down to. Well, the United Kingdom government were a party in NADA. It intervened on the question of jurisdiction, and it didn't for a second suggest, nor did the French government, which also intervened, that this was a particular procedural ground that gave rise to a question about jurisdiction, where jurisdiction was the precise objection that whether this was within jurisdiction for Article 1 purpose. Come on to look at NADA. But that was the objection, that was what the court was being considered, that was what the court was considering. It wasn't even hinted at by any of the states. In that case, or any cases subsequently. Perhaps if I take the court to NADA now, because you've heard me say much about it, it's in the authorities bundle tab 7. Starts at page 267, but can I ask the court please to pick it up at page 272? First point is paragraph 11. Can I ask the court to read that, please?
Yeah.
Italian national lived in Italy, no suggestion he had property in Switzerland. You see from the following paragraphs he was subject to a UN designation. And then further down, paragraph 18, you see what the Swiss government does is an exercise of its sovereign jurisdiction, passes an ordinance saying you can't travel through Switzerland. So that's what the Swiss government does, purely internal to Switzerland, on one view. Prohibits you from travelling through it. In paragraph 25, he then had his ability to move through Switzerland revoked. We know that is not sufficient. Doing immigration, taking steps to regulate immigration, we know that's not sufficient. That's what MN tells us. Paragraph 27, he wanted to go to Switzerland for medical treatment, and that request was refused. Again, we know that's not sufficient to found jurisdiction because the Grand Chamber has told us in MN. That led to proceedings against the Swiss government seeking to have his name removed from the list and to have his travel ban rescinded. And those proceedings were unsuccessful. And then it came before the Strasbourg court. So far, so MN, with the particular wrinkle that, as my lady indicated, that particular part of Italy in which his house was surrounded by Switzerland. Come on to see how the Strasbourg court dealt with that in a minute. Turn please to page 298, see where the court's reasoning starts.
Sorry,
298. See at the foot of the page, 102, you see the objection. Respondent government requested the court to declare the application inadmissible, being incompatible ratione personae with the convention, and that was because they said actually this was the UN Security Council that had brought this situation about, not us, not Switzerland. It wasn't Switzerland that brought this individual within our jurisdiction, it was the UN that were doing something. So that's the objection. You see at the foot of the page, you see, the objection continues on over to paragraph 103. And before we leave this, if we turn over to page 300, you'll see, just to make the point that I made earlier, the French government and the United Kingdom government intervened. So if the answer is that Homer nodded, not only is it the Grand Chamber that was nodding, it was the United Kingdom government and the French government.
Isn't that, I'm sorry to interrupt, Mr. Bowling, but isn't that because the submission made by the Swiss government was that the application was inadmissible, basically because it wasn't MEGA, but it was the UN. So that's the starting point for the dispute, isn't it?
Well, the starting point for the dispute was this is not an act for which Switzerland is responsible. That's the objection that's being made. It's not us.
Yeah, so it's an objection made to the admissibility of the application on a particular ground. So, I mean, did Switzerland object to the admissibility of the application on other grounds?
It didn't, my lady, no. And again, as I say, my submission doesn't go. My submission is not going as far as I fear you might be taking.
But it's the choice of the Swiss government whether or not to take a preliminary objection and which preliminary objection to take. And then if other governments intervene, they're intervening on the same basis as the basis of the preliminary objection, aren't they?
My lady, I'm not actually sure whether that is true or not as a matter of the convention. I did look at it yesterday.
Right.
And what there is a right for states to ask the president of the court to be admitted as an intervener.
Yeah.
And that is what they did. And they received that permission. So what I say is I don't go so far as to say it will be open to them to raise a particular ground of objection.
Right.
And have that determined. I don't think they could procedurally. But they could have made whatever observations they wished, bearing in mind this was a Grand Chamber case that they were intervening with.
But they could have done, but I think the point my lady's making is, of course, they could have done, but that wasn't what it was about.
My lord and my lady, and indeed, I have to accept this point. The submission only goes so far.
So, I mean, how far does this go? Because if it's not a case about jurisdiction, but there is, let's assume, a silent acceptance that there might be jurisdiction in such a case, it doesn't really give much support to an argument that there is a coherent body of law in
I
Strasbourg.
certainly don't. I don't go that far. I certainly don't go so far as to say there is a clear and constant.
So it doesn't go any further than MN.
Exactly.
But you can say, can you, without a clear and consistent application, because there's a reason why there might not be a clear and consistent line of cases, you can say, well, you've all done a fall within paragraph 1, 2, 3, for argument's sake, of MN, and we should therefore not go ahead of Strasbourg, but follow that.
I do say that. I say you are going no further than Strasbourg has gone. The principles on jurisdiction, I mean, the point that MN was making was that particular circumstances of a factual nature, they are exceptional. So they are always going to be exceptional, and sanctions, for the reasons I've...
I mean, the problem against you is that MN was a completely different case.
It was.
And so, in our language, the comments were pretty obiter, and it wasn't really thinking about sanctions or even situations of this kind. It was just saying, well, of course, one can envisage situations where the government would make itself exercise jurisdiction over a foreigner, but this is not the case because they banged on the Belgium door.
Exactly.
They went to the embassy and said, give me a visa, give me a visa, give me a visa.
And the counter distinction, and what I say, and that is why I say why it is very important that you look at the reasons why the court said that wasn't sufficient, by reference to their clear and constant case law. And what they say is the difference between that case and the case, and there's the examples they gave, where the state institutes criminal proceedings as an exercise of its own jurisdiction in respect of someone who's outside the jurisdiction. That brings them into the jurisdiction, the court said, because that's the state bringing them from the jurisdiction. That is the key distinction. I say that is what the clear and constant jurisprudence of the Strasbourg court is, and you can be satisfied that the court would go that far in a context where sanctions are.
Well, it's 1 o'clock. How much have you got left?
I will try. I think you've heard what I have to say about jurisdiction. I have to address A1P1, and I will do that as shortly as I can.
Right.
I will try to be finished within 20 minutes.
Is that a problem?
Well, that is quite problematic. I mean, we were working on the basis that my learned friends would have this morning, which is 2.5 hours. We would then have 2 hours. We're going to split the advocacy.
And we've got to finish very promptly.
And we've got to finish at 4:15. So my respectful submission is my learned friends should have no more than 10 minutes after lunch.
Okay, can you try and compress it as best you can?
I can, and it's fair to say that I've dealt with many of the points I would have needed to make a reply. So
Okay.
That won't be a problem.
All right. Very good. We'll resume at 2.
All right, please.